Hi. So today I am going to share with you about what is a Benami transaction. It appears that every Benami transaction is unlawful or illegal, but it is not so. Though it attaches a meaning of illegality, it is illegal only if certain conditions are applied to a Benami transaction. Now, Benami means no name. A transaction which is not having any name, which is a nameless transaction, is called a Benami transaction, which is an opposite of a transaction which has a name. So, what kind of transactions are not Benami transactions is what I am going to share with you today. In any Benami transaction, there are three elements. One is the true owner, the one is a Benami owner, the third is consideration. These three factors play a major role in a Benami transaction: the original owner, the Benami owner, and the consideration for purchasing that property. If the original owner is paying the consideration in the name of the Benami owner and purchasing property in the name of the Benami owner, and where the original owner, the Benami owner, who is also called ostensible owner or an apparent owner, and the consideration are transparent, then it is not a Benami transaction. For example, if father is buying a property in the name of a minor child, father is the true owner. Father can explain the source to the income tax department. The child is a Benami. He is holding the property in the name of a child in trust. He is trusting the child. So in this instance, technically the child is in the role of an agent. If the child is an adult also, if he became an adult also, he is holding the property in trust on behalf of the parent. So parent has a right. So here this is not a Benami transaction. It is a transaction of convenience. It's a transaction for many reasons. A transaction out of love, or a transaction out of a gift, or transaction out of any other reason. Here the consideration, the source, everything belongs to the true owner, the original owner of the property. And the Benami owner is an agent in trust. It can happen in many ways. Like a director of a company, if a director of a company is also holding property in his name, not in the name of a company, in his name, then he is an owner in trust. He is a Benami owner in trust. He cannot claim, or the income tax department cannot claim that it is a Benami transaction. On the face of it, it appears a Benami transaction. So the principle what you have to understand here is the source, the consideration, that is the amount that is paid to purchase a property, the availability of the original owner, the availability of a Benami owner, the explanation for the transaction. Though it is not necessary to explain in detail, but you should be able to explain if the income tax department asks for the details of the transaction. So if everything can be explained, and if everything is open, if everything is transparent, now Benami owner is an agent of the original owner. And the most important point is the original owner must show the transaction in his income tax returns. And the Benami owner also must show that the source is from the original owner. So both have to show the transactions to the income tax department, but in a different form, and explain to the income tax department that it is a transaction out of trust and the source came from the original owner. The Benami owner must explain to the income tax department that the consideration was paid by the original owner. And the original owner has to explain to the income tax department that the consideration was paid to the purchase of the property in the name of the Benami owner. So if this explanation is reasonable and convincing, then I think it is not a Benami transaction. It's a transaction of convenience. Hope I'm clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.